Okay, Mr. Lloyd, can you hear me, sir?
Yes, sir.
Mr. Lloyd, this is your preliminary hearing. This proceeding is not privileged, nor is it private. So I would caution you not to say anything that you wouldn't want the whole world to know, okay?
Yes, sir.
All right. For the record, this is position 30, state of Georgia versus Travion Lloyd. Mr. Lloyd is charged in warrant number 2022 WA 14487 with committing the offense of giving a false name, address, or date of birth. He's also charged in warrant number 2022 WA 14488 with pedestrian walking along the roadway. Mr. Lloyd is present in court, and he's represented by counsel. And the state is also present to prosecute this case. Is this going to be you, Mr. Tipton, or you, Mr. Taylor?
It will be me, Your Honor.
Okay. Mr. Tipton, would you swear in your witness and present your case? And Officer Singh, I'm going to ask you to turn your camera on. Thank you, sir.
Good morning, Officer Singh. Please raise your right hand. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You may lower your hand. Please state your name for the court.
Officer Singh.
Thank you. Thank you, Officer Singh. Officer Singh, how are you currently employed?
With John, police officer.
I'm sorry, sir. Your camera cut out.
Jonesboro as a police officer.
Oh, thank you, Officer Singh. How long have you worked there?
About 1 year and maybe 3 to 4 months.
Yes, sir. Have you were you working on September 15th, 2022?
Yes, sir.
What were your duties that night?
I was on patrol.
Okay. Did you approach, were you driving along Jonesboro Road near Highway 138 around 2355 hours on the night of the 15th?
I was stationary around that area.
All right. What did you observe when you were stationary observing that area?
I observed a black male leaving the gas station that's at Jonesboro Road at 138. And as the male left the gas station, he walked right across the street and not used the side or the crosswalk to cross across the street.
I'm sorry, sir. Did you say he used the crosswalk or he failed to use the crosswalk?
No, he failed to use the crosswalk and he just walked across the road and not the crosswalk.
Okay. Did you initiate a traffic stop?
Yes.
All right. From what you see, were you able to estimate how far away he was from the crosswalk?
He was about 50 to 60 feet away from the actual crosswalk that he did not walk to use, just briefly cross across the road.
All right. Did you, when you made contact with him, did you ask for any identification?
I asked him for his ID and he told me that he didn't have it with him at first.
I see. And so when he told you he didn't have his ID, what did he do?
So I told him to write his name on my notepad. And when he began writing a name on the notepad, he was writing it very slowly and looking up. And to my experience, when somebody does that, it's often they're writing a false name. And I told him to stop writing it because if he kept writing a false name, I would see the picture that came on that name and then I would see it's not him. So he stopped writing it and he scribbled it out. And then he wrote his real name. And I asked him whose name he was writing, and he told me that he was about to give me his brother's name because he knew he had warrants.
And do you recall what name he started writing down?
He wrote to him on my notepad because he scratched it out. So what I was able to make of it was a Jumaane.
I see. And were you able to discover the defendant's actual name and and what did he clarify his name to actually be?
Trevin Lloyd.
I see. Okay. And did this occur in Clayton County?
Yes.
Okay. No further questions.
Mr. Suh, is
Thank you,
this,
Your Honor. Yes, sir. Yes, sir.
go ahead.
Yes, Your Honor. Let's see. Good morning, Mr. Officer Singh.
Good morning.
Just a couple questions. First question is, what was the traffic condition like on this particular day?
It was a normal light traffic on the roads.
Who had possession of the notepad when you saw the name that looked like Jumaine? Or when he was writing whatever he was writing?
He had it. I gave him my notepad and my pen to write it. So he had the whole thing in his hand.
No further questions at this time, Your Honor. Just argument.
Yes, sir. Any other witnesses, Mr. Tipton?
No, Your Honor, the state's resting.
May Officer Singh be excused?
Yes, Your Honor.
Officer Singh, you may be excused, sir. You can choose to stay on and see the rest of this if you want to, but you're no longer required to be here.
Okay. Thank you, sir.
You're welcome. Okay, Mr. Tipton, are you gonna waive opening or?
I'll waive opening and reserve closing.
Okay, Mr. Suh.
Thank you, Your Honor. Your Honor, Mr. Singh was a very good witness in the sense that he told us several things. Let me just go back through it. The first thing I asked was who had possession of the notepad when the name that could have been Jumaine was written down. It was the defendant. Mr. Officer Singh even said that he couldn't really make out what the name was because the defendant had scratched it out. The officer indicated that his experience taught him lots of things of what the defendant was doing. Everything indicates that it looks like Mr. Singh helped Mr. Trevian not give false information by giving him a tip early. He never actually presented the false or any type of false name to the officer. And even though there may be the mens rea, there might be sufficient probable cause for that, there is no actus reus. He didn't actually give him a false name. The officer even said he doesn't know what name he wrote down because he scratched it out before he gave him his real name. So when it comes to giving false information, I'm going to say that it's very clear he didn't give him a false name. There may be an argument to say he tried to or thought about it, but thought alone isn't enough. You need the act. So for giving false information, we're going to ask that the charge be dismissed for lack of probable cause. For pedestrian on the roadway, I will submit on the evidence.
Mr. Tipton?
Yes, Your Honor. So this argument that there was no actus reus doesn't hold water when you take time to think about what the witness's statement was. The witness specifically stated that he wrote down Jumaine. Those letters would not match with Trevion. He might have mistaken a T for a J, but I don't think he would mistake an M or several E's or several A's or an E as being the name. He actually wrote down Jumaine. The officer specifically told him, no, you shouldn't do that, but he still did it. He did it prior to the officer making that suggestion. As far as pedestrian in the roadway, Your Honor, he was 50 to 60 feet away from a crosswalk. He was trying to avoid a crosswalk, and that's pretty cut and dry on that, Your Honor. Going back to this false name, he specifically was trying to give a false name because he had warrants, because he didn't want to be found. And when he asked the accused specifically told him that he was in the process of giving him his brother's name and date of birth, which he had already started to do. Jumaine is not Travian. It's really that cut and dry, Your Honor. And with that, the state's going to rest their argument.
Thank you, Mr. Tipton. I'm gonna dismiss the giving a false name, address, or date of birth based upon the testimony that I've heard. The pedestrian in the walkway, or the along the highway. I think the evidence is clear as it relates to that, but as I heard the evidence, he may have started to do something and was told not to do it, and then he didn't do it. So I'm going to dismiss that charge.
Thank you, Your Honor.
Okay, let's bring up Officer Ritchie for the criminal trespass with Mr. Lloyd. Okay, for the record, this is going to be position 32, State of Georgia versus Travion Lloyd. Mr. Lloyd is charged in warrant number 2022 CW 50770 with committing the offense of criminal trespass. Mr. Tipton, would you please swear in your witness and present your evidence?
Yes, Your Honor. Officer Ritchie, would you please raise your right hand?
Yes, sir.
Do you swear or affirm any testimony you give today shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, Officer Ritchie. Officer Ritchie, please state your name for the court.
Officer Ryan Ritchie,
Officer Ritchie, where are you currently employed?
the Clayton County Police Department.
How long have you been employed with the Clayton County Police Department?
Approximately 9 years.
All right, sir. Were you working on the night of February 16th, 2022?
Yes, sir.
Did you have occasion to go to 7180 Woodlands Circle in reference to a domestic dispute?
Yes, sir.
So when you arrived, what occurred? What did you see?
We arrived and we made contact with the caller, Miss Hearn. She stated that she had come home and discovered damage to her, some of her doors inside the residence, and she met with the other two residents, the two witnesses, Marcus and Kendarius, I believe, and they stated that they heard a loud bang and observed Lloyd coming from the area that loud bang had come from, and then noticed the damage to the doors inside the residence.
Let's see. And did you observe this damage yourself as well?
Yes, sir.
Okay. What did it look like it happened to those doors, sir?
We observed one hole in the upper portion of the door on the top level of the home that was about the size of a fist. And we observed a split through the center of the door leading to the laundry room on the lower level of the house.
I see. And did you make contact with Mr. Relaford and Mr. Wright separately?
Yes, sir.
Did they both tell you, did both of their stories match up?
Yes, sir.
All right. And did they both identify Mr. Lloyd as the person they saw walking away from the doors after they heard the loud bang?
Yes, sir.
Okay. Did all this occur in Clayton County?
Yes.
And were you able to determine who was in lawful possession of or owned the doors?
Yes.
Okay, and who possessed or owned the doors?
That would be Miss Hearn.
Okay. Thank you. No further questions at this time, Your Honor.
Mr. Suh?
Thank you, Your Honor. Good morning, Officer Ritchie.
Good morning.
You indicated that you had separate discussions with both Mr. Relaford and Mr. Wright, and then you said that their stories matched up. Could you give us a little more information about what their stories were?
They just both stated that they heard the loud bang and then observed Mr. Lloyd coming from where the loud bang had occurred and where the damage was.
Did you ask any of the three witnesses, that includes these two as well as the owner, Ms. Hearn, did they indicate that damage wasn't there beforehand or something?
Yes, sir. Ms. Hearn indicated that that damage was new damage.
So just to be clear, these two witnesses didn't actually see the defendant do the actual act. They heard it and they're kind of putting two plus two together.
Yes, sir. That's correct.
No further questions at this time, Your Honor.
Mr. Tipton, do you have any other witnesses?
I do not, Your Honor.
May Officer Ritchie be excused?
I just want to ask him two more brief questions and then the state will rest.
Yes, sir.
Officer Ritchie, I just want to make sure that I'm getting the timeline right. So the witnesses, three questions actually. So the first question was, you confirmed that there was no damage prior to the sound of the loud bang. Is that correct?
Yes, that's what Ms. Hearn advised.
Okay. And then you advised that several witnesses heard a loud bang. Is that correct?
Correct.
And you also stated that there were two witnesses out of the three who observed Mr. Lloyd leaving the property immediately after, or leaving the area where the damage occurred immediately after the loud bang. Is that correct?
Yes, sir.
No further questions.
Mr. Suh, any recross?
No, Your Honor. Probably just a
Okay.
short argument.
Okay. Mr. Ritchie or Officer Ritchie, you may be excused. You're perfectly welcome to stay and see the end of this proceeding, but you are no longer stay here, okay?
Thank you, Judge.
All right. Mr. Tipton, are you going to waive opening?
Yes, Your Honor, I'll waive and reserve.
Okay. Mr. Suh.
Thank you, Your Honor. Your Honor, a lot of this case has to do with third-party information. And of course, at a preliminary hearing, hearsay is allowed. But its officer even indicated that nobody actually saw him do this alleged damage. I feel like to be charged with a crime and to lose your freedom, you got to have a little bit more than just mere accusations. So I would ask that the charge be dismissed for insufficient probable cause.
Mr. Tipton?
Your Honor, the state believes that probable cause does exist. It's a simple case. It's a simple case of, as Mr. Suh put it, putting two and two together. You have damage that wasn't there. You have a loud noise. You have a hole and a split in a door, and you have two witnesses whose stories confirm that they saw this person walking away from something. If we couldn't prosecute someone just because we didn't have an eyewitness to criminal trespass, half our criminal trespasses wouldn't exist. And the state, is very confident that this is a strong case for a criminal trespass. Mr. Lloyd, it was established that there was no damage. It was established that there was damage to the door, and it was established that Mr. Lloyd was leaving the scene, and it was confirmed by two separate witnesses who spoke to the officer separately. That to me just signals probable cause, Your Honor. With that, there's nothing further from the state.
I'm going to agree with Mr. Tipton on this, Mr. Suh. This is the quintessential case of you fall asleep and the ground is dry. You wake up in the morning, the ground is wet, and you don't see the rainfall, but you can, at least the state is gonna have the opportunity to try to pull those dots together. So this case is going to be bound over to state court for this charge. You're welcome. Mr. Lloyd, sir, you can go back and just, I'm going to rely upon the parties to just, if you know that you have a case, I see several officers here. If you know you have a case that you want to move forward on, just let me know.
Your Honor, on the
Yes.
matter of Raylene Pinkett, we have a witness that's a private citizen, the victim in the case, and he has limited availability before he has to go in to work.
Okay.
If we could proceed with that matter next, that would help him.
Yes, yes, sir. Who is the witness?
Solomon Walker.
And you said Raylene Pinkett?
Yes.
Okay.
And Mr. Walker.
Yes, sir.
Good afternoon, sir. Well, good morning. Sorry. We're going to try to proceed with your case. I am going to announce the case, and then I'm going to turn it over to the state to proceed with their part of the case. I will simply ask you to just respond to the questions that are asked. Do you believe you can do that, sir?
Yes, sir.
And looks like we have Raylene Pinkett up at the jail. Ms. Pinkett, this proceeding is neither privileged nor is it private. So please don't say anything that you wouldn't want the whole world to know. Okay? For the record, this is going to be position 42, State of Georgia versus Raylene Pinkett. She's charged in warrant number 2022 WA 14378 with committing the offense of criminal trespass. So also charged in warrant number 2022 WA 14379 with committing the offense of battery. And also charged in warrant number 2022 WA 14380 with committing the offense of criminal trespass. Warrant number 2022 WA 14381 with committing the offense of driving on a suspended license. Warrant number 2022 WA 14382 with committing the offense of hit and run. And lastly, warrant number 2022 WA 14383 with committing the offense of driving under the influence of alcohol to the extent she was a less safe driver. Ms. Pinkett is present here in court. She's represented by counsel. The state is here. Is it going to be you, Mr. Taylor?
It is, Your Honor. I'll be presenting this case.
Your Honor, before we proceed, I just want to get confirmation. Are we working on, so there's two separate case numbers associated with Ms. Pinkett. Are we proceeding with both case numbers at this moment or just one of them?
So you have to fill me in with more knowledge.
Your Honor, the two matters they're separate, but they're related. They're divided by just maybe minutes to half an hour in time. The first matter is related to the incident between Mr. Walker and Ms. Pinkett. The second matter is related to driving offenses after Miss Pinkett left the area where the altercation with Mr. Walker occurred.
So
But he would have information regarding that.
I'm sorry.
He would also be able to testify to information regarding the driving incident.
Okay. So, Mr. Suh, it would appear, to answer your question
Yes, Your
directly,
Honor.
we're gonna proceed on all charges.
Yes, Your Honor.
Okay. Go ahead, Mr. Taylor.
Okay, Mr. Walker, could you raise your hand, please? Do you solemnly swear that the evidence and testimony you shall give in this matter before the court shall be the truth and nothing but the truth, so help you God?
Yes, sir.
Can you please state your full name?
Solomon D'Angelo Walker.
Okay. Mr. Walker, could you tell us the nature of your relationship with Miss Pinkett?
That's my girlfriend.
Yes. And was she your girlfriend on September 14th of 2022?
Yes.
How long have you and Miss Pinkett been in a relationship?
About a year and a half.
Okay. And do you reside at 934 Garden Walk Boulevard?
Yes, sir.
Is this in Clayton County?
My address says Atlanta, but I guess so. Clayton County, if you want to say that, yeah.
Okay. Could you tell us about the incident that occurred between you and Miss Pinkett on September 14th?
I mean, it wasn't. She had just grabbed my PlayStation and my TV. I just wanted my PlayStation and my TV back. And, you know, she just in her mood and didn't want to give it back. And that's everything kind of got out of hand, but it wasn't violent and it wasn't nothing like that. I was just asking for my PlayStation back. I like to play the game. She just took the PlayStation and took it to her car.
Okay.
And, you know, it just went left field from there.
Going back a little bit prior to that, can you tell us how the evening started? Just, were you having dinner with Miss Pinkett?
Yeah, I came home from work. We fried chicken, we ate. We watched TV. I was about to get ready to lay down and go to work. And we was just having a conversation I guess went left field.
Mm-hmm.
Yes, sir.
And so you had an argument, right? A
Not a
disagreement.
major art.
A disagreement.
Yeah.
Okay. Were you drinking during dinner?
I had a couple beers.
Was Miss Pinkett drinking during dinner? Alcohol?
No, she wasn't drinking. I had a couple beers that I brought home from work, so I didn't bring her no beers.
Do you know if she had had anything to drink prior?
I wasn't at home, so when I came home, she could. I didn't see her drinking.
Okay. So you said that Miss Pinkett took your PlayStation and I believe a television. Is that correct?
Yes, sir.
What did she do once she took those items from you?
Oh, she just put them in her car. That's all that happened.
Okay. Did she leave the location? Did she leave your residence?
Yeah, she left the residence. I mean, that's how she got stopped. But yeah, she left the residence.
When she left the residence, can you describe anything else that happened to your property or to anything else you may have witnessed?
Now, when she left, she was gone. I mean, when she left the property, and they just came back and brought the stuff back. One of the officers came back and brought the stuff back. So I can't say nothing else that happened after she left.
Okay. When she was driving away, when she was leaving your residence, Did her car strike your car?
Yes.
Okay. Did she do anything? Are you aware of her doing anything to your car prior to her leaving the location?
No, sir.
Okay. So, and after that, after this incident, after she left, when did you see her next?
I mean, right now.
Did she not come back to the location in the company of police officers?
Yeah, one of the officers told me she was there, but I didn't even know she was there. I didn't know she was there. The officer told me that she was there.
Okay. You said earlier that you've been in a relationship with Miss Pinkett for about 1.5 years, correct?
Yes, sir.
Are you aware of her having any other driving offenses prior to the arrest that occurred on this night?
I mean, yes, she had an incident before since we've been together. She has. I know about that one. Yeah.
Was that a DUI?
I'm assuming. I think that's what she said they charged her with.
Okay. Did you know about the status of her driver's license? Did she share that information with you?
No, sir.
Okay. So just to recap, there was an argument or disagreement between you two, correct?
Yes, sir.
And one of the reactions during that argument was she took your PlayStation and placed it in her car,
Yes, sir.
and she drove away.
Yes, sir.
And she, in the course of driving away, she ran into your vehicle.
Yes, sir.
And she continued to drive away after she ran into your vehicle.
Yes, sir.
Thank you, Mr. Walker. That's all the questions I have at the moment.
Mr. Suh?
No questions for Mr. Walker, just closing argument, please.
Okay. Mr. Taylor, are you gonna waive opening?
Yes, Your Honor, I'll waive.
Okay.
Your Honor, I'm sorry. It looks like our officer was finally able to get on for this case, Officer Allen.
Okay, I just saw Officer Allen. Is it the state's?
If Officer Allen's present, the state wishes to call Officer Allen as a witness.
Okay, you may call Officer Allen.
Does Mr. Suh have any questions for Mr. Walker before we release him?
Well, he
Actually, no questions still.
okay.
Okay. Then the state calls Officer Allen.
Okay. Did he
Hi, Officer
swear?
Allen. Could you turn on your camera, please?
Yes. And you can swear in your witness. And Officer Allen, if you would do us a favor of try not to move around.
I got you. Yes, sir.
Thank you.
Good morning, officer. Could you raise your hand, please? Do you solemnly swear that the evidence you shall give in the matter before the court shall be the truth and nothing but the truth, so help you God?
Yes, sir.
Thank you. Could you state your full name?
Officer D. Allen, Clinton County Police Department.
And what is your position with the Clayton County Police Department, sir?
Uniform patrol officer.
And do your duties include responding to domestic disturbances?
Yes, sir.
Do they include any traffic duties?
Yes, sir.
Were you working on the date September 14th of this year?
Yes, sir, I was.
And did you have occasion to make contact with Mr. Solomon Walker,
Yes, sir.
could you describe how you came into contact with Mr. Walker?
I arrived at a location. As soon as I pulled in, Mr. Walker was standing outside. He advised that he and Miss Pinkett engaged in a disagreement as they were eating dinner on the balcony outside. When Miss Pinkett became upset, took his PlayStation 4 and his 32 Hisense television. Once she took that property, Mr. Walker advised he then went to his vehicle and put his car behind her car, and then began to call 911 when the physical altercation occurred. After that, it was a physical altercation. Miss Pinkett pulled the keys out of the ignition, threw the keys, as well as punched the driver's side mirror of the vehicle. She then pulled off and proceeded outside the apartment complex. At that point in time, Mr. Walker was on the phone with us with 911, and he gave a description of the vehicle that she was driving. When we had an assistant officer that was able to locate her on Garden Walk Boulevard, when he immediately put her in custody due to her driving with a suspended license.
And you said that there was a physical altercation between Ms. Pinkett and Mr. Walker.
That's affirmative.
How did you see this physical altercation?
No, sir, I didn't. I wasn't there.
Mr. Walker described it to you.
To my best knowledge, he said that his hair was pulled and he was hit multiple times to the back of the head. And then as far as the physical evidence, he had a scratch. During the altercation, there was a scratch on his left hand.
And when Ms. Pinkett left the location, was that without incident or did something else occur?
After the incident, she did hit his vehicle as she was leaving outside the apartment complex, and it was damages on both vehicles that were consistent.
And you observed that damage, correct?
Yes, sir, that's affirmative.
Okay. Following the incident at the residence, did you have a later contact with Ms. Pinkett?
I did for a brief moment. She was read her Miranda rights, and I tried to, ask questions, but she refused to answer any questions.
And where was Ms. Pinkett placed under arrest?
Originally, it was on Garden Walk and I believe near Eagles Crossing.
Yes. Okay. Is this in Clayton County?
Yes, sir.
And was she placed under arrest solely for the events that occurred at the residence?
Well, initially it was for the traffic offenses, which was the suspended license. And then once we had everything else and all the evidence and facts, we were able to confirm that she was also for the family violence offenses as well. So she was placed in custody for everything.
Okay. You said that during the traffic stop, it was identified, or it was you were able to learn that her license had been suspended?
Yes, sir. And I was at the incident location, so I wasn't at the initial traffic stop and made the first contact with her.
But the officer at the traffic stop made you aware of this. Is that correct?
Yes, sir. And she was eventually brought back to the incident location.
Investigator Ridgeway, can I help you, please?
Hello, I was trying to
Hold on. Okay, go ahead. I'm sorry.
Thank you, Your Honor. So the traffic stop, she was arrested, or she was charged with driving under a suspended license. Was there another charge?
It was also driving under the influence, let's say.
So she was charged with a DUI. Is that correct?
Yes, sir.
And you were made aware of this by the arresting officer?
Yes, sir.
I think you said that you had contact with Ms. Pinkett when she was brought back to the residence. Is that correct?
Yes, sir.
Were you able to observe her appearance?
The only thing I observed was she was in the back seat, and I could just smell the strong odor of alcoholic beverage coming off of her breath. So that's pretty much the only observations I had with her.
Okay, thank you, officer. No further questions at this time.
Mr. Suh,
Thank you, Your Honor. Good morning, Officer Allen.
Morning, how you doing?
So I want to focus on the DUI a little bit. Just to confirm, you just said that you smelled the strong odor of alcohol, right?
Right.
But that did you make who was the officer that actually arrested her for DUI?
We have Officer Timmett. He actually did the traffic offense stuff and the hit and run, as well as the suspended license.
Gotcha. Are you aware whether he did a field sobriety test?
To my best of knowledge, she did not.
No, I'm asking, are you aware whether he even asked? I guess that's speculation.
I know that it
Mhm,
wasn't at that time. It wasn't done.
It wasn't done.
No, sir.
Are you aware whether she took a blood test, urine test at the station?
I'm not aware. Not aware of that part.
Are you aware of whether the officer read implied consent regarding any type of blood test?
I'm not sure on that part, sir.
Mr. Suh, if I can stop you and maybe move this along, I've not heard any evidence to support a DUI.
Thank you, Your Honor.
Charge.
No further questions at this time, just closing.
Okay.
Can I say
So,
something?
Mr. Walker,
I'm sorry, Your Honor. I was just saying if I could say something right quick. If that was fine.
I'm gonna allow it.
Okay, yeah. I was just explaining to the officers at the scene, like I wasn't trying to press any charges. I wasn't trying to make this go any type of way that it went. I just wanted my TV and my PlayStation back. You know, that was it.
Okay.
I
So, Mr. Walker, I'm gonna stop you right there. I generally tell people the way to not press charges is to not call the police. These police officers are not concierge people at a hotel where you just bring them up when you want something. They're there for a specific purpose. And when you call them, they're there to do their job. So I understand that. That's going to be a discussion that you're going to have with the Solicitor General's office about how far they're going to move this case. Okay? You and Miss Pinkett, y'all get into a dispute. Disputes happen in relationships all the time. But when people start calling the police, you're bringing a third party in. And that third party that you have invited to that party, they get to make their own decisions. And the best way I say it is that when you invite ants to the picnic, they're gonna be coming over your food. So you can't invite the ants to the picnic and then say, why are these ants eating my food? So, Mr. Walker, in the future, sir, if you and Miss Pinkett stay together, that's a decision the two of you have to make. If y'all have a disagreement, y'all are adults and you need to act like adults. You act like children, you're going to get treated like children. Do I make myself clear, Mr. Walker?
Yes, sir.
Thank you.
And I had one more question they told me to ask. One more question
Yes,
I wanted to
yes,
ask.
sir. Yes, sir. Yes, sir.
They just wanted me to ask, you know, I'm at work, so I'm just talking real fast. I'm talking quick. Could we lift the note? Is that they said I had to present it to the judge? Could I lift the no contact order so I could come see her and visit her? Like, is that possible? Because they said bring it up to the judge.
Okay, so that goes through the solicitor's office. And they have their own investigators. They look into it. They make a determination. And if they bring a recommendation to the court, that recommendation will be accepted. But we don't have the ability to go out and investigate. As far as I know right now, this incident was just out of character for both you and Miss Pinkett. Or the police came just before Miss Pinkett killed you. I don't know that because I don't have that ability to investigate that. So because we got the third parties involved, the proper channel is to go through the solicitor's office, lay everything out on the table, and they will investigate and they will make a determination.
Understand?
Okay. And I'm sorry, Mr. Walker, but this happens so often. Police officers, they're not mothers and fathers. They're not the people that are supposed to come in and exercise parental guidance. When they're brought into the situation, they do what they're trained to do. And then we all have to deal with it and we all have to understand. So I hear you, sir. And what I hear you're saying is that this was something that was not normal, but you're going to have to communicate with the solicitor's office and let them go through the proper channels. Okay.
Yes, sir.
All right. Mr. Suh, I'll listen to you.
Yes, Your Honor. Are we ready for closing?
Yes, sir.
Thank you, Your Honor. When it comes to the charge of battery in the first case number, got some conflicting testimony. I've got the alleged victim here in court present saying that it was just about a PlayStation, not violent or anything like that. Those are his words of the alleged victim. Now we have an officer saying something different, talking about hair being pulled and smacking in the back of the head. Your Honor, I think that's presents major conflict. If it was just a random third person, that'd be one thing, but the alleged victim himself is saying that it was not violent or anything like that, his specific words. So for the charge of battery, I will ask that this that charge be dismissed for lack of probable cause, as well as the DUI charge. It was indicated that there was no field sobriety test, there was no blood test done. Not sure if implied consent was done. We don't know anything about that. All we hear is that the smell of alcohol, and case law is very clear. You cannot convict on a DUI for just smell alone. Even the admission is not insufficient because the law is clear with DUI. It's not you can't drink and drive. You can't drink beyond the legal limit and drive. That's a very key distinction. You can have a beer and not get DUI'd. I wouldn't recommend it, but you can. When it comes to the other charges, criminal trespass, 2 counts, license suspended, hit and run. For those charges, we will submit on the evidence.
Okay. Mr. Taylor.
Yes, thank you, Your Honor.
The DUI, well, let me focus you a little bit. The DUI and the battery charges are the ones that I'm most concerned about. I'm not concerned about the other charges. So if you would just focus your
Well, Your Honor, I would, with regards to the DUI, Officer Allen did testify that smelled alcohol, a strong sense of alcohol, when the defendant was brought back to his location back at the residence. I would submit that her driving, most people would not, under a non-intoxicated or in a sober frame of mind, would not back into a vehicle that they know is behind them. The defendant's car was parked behind her, and she struck it and then continued on her way. I would submit that gives the court, along with the presence of alcohol in her breath as testified by the officer, that she was not in a regular frame of mind, and that was likely due to intoxication. Certainly anger would play a part in that, but having hit the car, most people, if they strike another vehicle, it brings them to a sort of consciousness that, hey, maybe I need to slow down and think about my actions. But however, Ms. Pinkett continued to proceed to drive, and in a state of anger and in a state of, at least under some form of alcohol intoxication, whether it be a minor amount or a significant amount, she continued to drive and put others at risk. So I would submit that it is, and Mr. Walker testified that she had a previous driving problems, and her license had
Yes,
so
that's true, but his testimony was that he didn't observe her have any alcohol on that day.
Certainly, Your Honor, that's correct. As to the battery, I believe Mr. Walker is he's concerned about his girlfriend. I think the battery occurred, and he described it accurately at the time. And his testimony today may be biased and influenced by the fact that he does not want to see his admittedly ongoing relationship with Ms. Pinkett. He doesn't want to see her harmed by further criminal proceedings, or would like to minimize this as much as possible, and it's understandable. But I do believe the battery occurred as the officer described it.
I tend to agree with you, Mr. Taylor, but I have to go upon the evidence that I hear. So position 42, the criminal trespass is going to be bound over to state court. Position 43, the battery is going to be dismissed. Position 44, criminal trespass is going to be bound over to state court. The driving on suspended license is going to be bound over to state court. Hit and run accident is going to be bound over to state court. And the DUI alcohol less safe is going to be dismissed. But I do, and Mr. Walker, if you're still there.
Yeah, I'm still here.
I do believe that you're trying to protect your girlfriend here today. I'm just gonna again remind you that the next time, if you and Miss Pinkett stay together, next time you're in a disagreement, don't call the police.
Yes, sir. You're right.
And I mean, unless you really fear that something is going to happen, don't call the police. These officers, they're not like play toys, and they're not hall monitors. They're here to protect and serve the citizens of this county.
Right.
And if you didn't need protection on that day, you're taking them away from someone else that did need protection.
Yes, sir.
All right. Is there anything else for this case?
Nothing further from the state, Your Honor.